Right, this is Laws 12066 Land Law, and this is the lecture for, or the presentation for week one, which is an introduction to land and the nature of land. So welcome to the course, people, welcome indeed, and you will have already completed, satisfactorily completed Laws 12065, Foundations of Property Law with me. Some of you may have just completed that. Some of you may have completed that a little while ago. Others may have already satisfied those requirements through studies at possibly another university and have now come to the fantastic CQU online law program. All right, so in this introductory lecture, I just want to basically point out a few features of the course. I want to provide a little bit of a roadmap for where we'll be going over the course of the term. Indicate some of the resources that you'll need to have at your disposal and consult throughout the term and our studies on land law. Talk about assessment, very important and near and dear to the hearts of all of us. And also just introduce you to some of the broader ideas, but in particular to bring to your attention the impact that technology is having in this area of the law. Technology, of course, is transforming everything, as we know, right? It's revolutionising our life and the world as we know it. But in the study of land law, we will find that it has particular resonance and application. And I want to suggest to you, even at the outset, that that is certainly from a perspective of process and procedure with regard to land transactions and land dealings. But it will also become obvious, I hope, that it has a broader impact than that, and it has the potential to reorient how we think about some of the fundamental principles that we're going to be exploring in land law over the course of this term with each other. All right, so without further ado, I'm just going to screen share a few items. So I'm going to start by just screen sharing the slides. So there we are. That's what we're covering in this first lecture. And in this introductory class, we're just trying to get an idea around how do we identify and articulate concept of land from a land or property law perspective. And what does that involve? What does that entail? What does that include? To identify and reflect upon the development of a uniquely Australian real property law, so that we've seen already to some degree in the Foundations course that property law has a trajectory that goes back to very early English history, and there has been, a continuation of some case law that continues to have relevance in the Australian jurisdictional context, and then in the States, because property law is often, not always, but as we'll see increasingly in this course in land law, subject to state-based legislation, so within the states and territories. But what's occurred over time is that we now have what is arguably a unique Australian real property law. So that's something to bear in mind and to be mindful of as we progress. And then the other point I want to just identify is that we need to look a bit more deeply and reflectively as we think about land and the nature of land and how the law regulates that. And so one of the features here is that I want to actually get you to think about the social purpose of real property law as something that is a dimension in thinking about the nature of how the law regulates and governs interests in land, transactions with respect to interests in land, dealings in land, instruments with regard to land, and so on. What's the larger purpose here with regard to what's actually transpiring? And ultimately, one can think also about what should be occurring. Going forward into the future, if this is an area that you find appealing and you like to work in the area or have contact with the area, then as a practitioner, if you're in private practice, then you'll be acting for clients in regard to transactions, sales, purchases, mortgages, leases, and so on. But you could also be working in policy areas. You could be working for a government agency, a government department. You could be working for a law reform body. You could be working for a land council, possibly. You could be working in a new area that hasn't yet been identified, where your skills will be important and relevant. So this idea of these deeper purposes are important. Some key terms. We think about real property law, and then we think about broad environment of land and land law. And that's an image which we've seen before, goes back to foundations and our coverage of native title. And it's just something as, to give us an idea of the vastness of land, in a sense. But the land law that we're going to be focusing on in this unit is essentially the law which has evolved over time and now has a uniquely Australian character to it, with regard to the regulation of private freehold land. In foundations, we looked at broader, different areas, other topics, native title, public land or state land in Queensland. Almost entirely, this unit is devoted to the law that's regulating and governing private freehold and interests in private freehold. The one exception to that is the topic on social housing, which I'll talk more about shortly. All right, so before we come to the idea of the concept of land, I'm just going to stop screen sharing that for a moment and just want to screen share. Where are we? Yeah, so I just want to screen share the notes for topic 1. So just on the prescribed texts, I'll just stop screen sharing that for a moment. And so we know that we continue with the slim volume in the Edgeworth casebook of Australian Real Property Law, the Sackville and Neve as it's generically referred to, the 10th edition, which is a 2016 edition. And if you have been studying with me in Foundations this year, then you will have that casebook. And we continue on with that casebook. It's a 2-for-1, people. So you get 2 courses or 2 units out of that casebook. And the other book, which we're using, and we use this in Foundations as well, that's the Q&A book by Laura Lee Cameron Dow. We use some of those questions in the tutorial questions. So I'll just go back to screen sharing again. So they're the 2 prescribed texts. And yeah, just a note there with regard to, you know, the material. The material is at times demanding. There's an amount of material to get through, and I will try and aim as best as possible to focus you on the key features, the key concepts, and the key law that you need to be mindful of, and always be aware that we're thinking and have a mind towards the current law. We'll talk about some reforms that are on foot just in a moment. Some further references that I think quite useful for you, and that is the Wallace, Weir and McCrimmon Real Property Law in Queensland. Now, that book looks like this. Just going to stop screen sharing that for a moment. So that's Real Property Law in Queensland. That, not suggesting you should get a copy of that, but I have for different topics in the course, I have uploaded some material from that book because, again, as I mentioned at the outset, land law, more so than the foundations course or foundations unit we did, is quite jurisdictionally based, because the relevant legislation is state-based legislation or territory-based legislation, but for us, Queensland legislation. And then the case law that emerges in discussing key concepts and key provisions within that state-based legislative framework. And it's not exactly the same. They're not mirror versions of each other around the jurisdictions. So very important to remember, we're benchmarking against the Queensland legislation, and then whilst the Property Law Act, which we looked at and considered in the Property Law course in Property Law Unit in Term 1, will continue to have relevance. Key act for us is the Land Title Act, which is the Torrens Act. And after this lecture, and this topic, we spend the next 3 weeks on the Torrens system and immerse ourselves into the Torrens environment. But that actually abides throughout the unit. It's not just locked into those 3 topics. It then continues, because in Queensland, all private freehold land today is Torrens title land. Okay, there is really no old system title, which we'll just mention briefly when we look at our introduction to the Torrens system in the next lecture. But that, having said that, that resource is useful. Now, I'll just go back and screen share again. So I've referred there to another work, which is Edgeworth's, Butt's Land Law, 7th edition, 2017, by Brendan Edgeworth. And I'll show you what that looks like. That looks like that. You can see my books are all well thumbed and well posted, marked up, and so on, which is the way that I tend to function. That's a really good reference work. And again, I'm not suggesting at all that you purchase that, but it's a really good reference. It does tend to have a bit of a New South Wales focus, but all the other jurisdictions and the cognate legislative provisions and so forth are referred to in footnotes, and sometimes also in the text. But it has an interesting perspective on different areas of the law. And from time to time, I might suggest that you might like to have a look at that. And from time to time, I might have uploaded or will upload some material from Brendan's 7th edition. It's a very recent work, and it's really excellent work as a reference work. That's just emphasise that. So just want to come back again to the notes. Just the purpose here is just to give you an overview of where we're going. Okay, so we are. This is where we're tracking in terms of the topics that we're looking at in the course. So once we've dealt with the introduction and the concept of land in this lecture and topic, we then, as you can see, we spent 3 weeks on the Torrens system. Now, the Torrens system is fundamentally important in land law in Australia. It's a system of title by registration. As I mentioned earlier, it's in Queensland, all freehold, private freehold is Torrens title land. And so it's critical that you get a good fundamental understanding of the mechanics of the Torrens system, the key features of the Torrens system, and what are the main themes. And you can see there that we're going to look at it. Indefeasibility. Beautiful concept, people. A beautiful concept. Indefeasibility. Exceptions to indefeasibility. And then, yes, equity comes to the fore again. We saw that in property law, but it's sticking its head up again. And equitable interests, unregistered interests, and compensation provisions. Because one of the key ideas within the Torrens system is that it is a state-guaranteed system of title by registration, so that if something goes wrong, if there is an error, someone loses their title, and that's provable against the legislative framework, then compensation can be available. Not always, but can be. We are moving in an innovative way in this space because 3 jurisdictions in Australia, not Queensland, but New South Wales, Victoria and I think South Australia, have made moves, and New South Wales has actually completed this process to privatise or commercialise the Torrens register. So that raises interesting questions about assurance and who takes responsibility when errors and problems arise. We'll talk more about that when we get to discussions in the Torrens topics. From there, we go on and we look at a series of topics that are pretty important in land law. We spend a week looking at co-ownership, and we've already seen that. We saw co-ownership surface in the context of acquisition of property rights and also equitable property back in property law foundations. Here we're going to look at it a bit more thoroughly in terms of rights and responsibilities and obligations and what happens where co-owners are in dispute and what happens, you know, the relationship breaks down and how can you come out of a co-ownership situation and what are the different types of co-ownership that's possible under the land law. So we spent a week looking at that, or a topic on that. We then look at alienation of proprietary interests and the rule against perpetuities. Alienation is, again, almost goes back to an idea about the purpose of the use of land, that it serves economic purposes, it serves purposes of habitation and livability, in truth, right? In a whole lot of ways, personally, commercially, industrially, agriculturally. But again, our focus here is on private freehold, not on the vast terrain of land. And that private freehold, by the way, is probably only about a third at most of the total land mass of Queensland, let alone Australia. So alienation is a big idea, and the common law has for a long period of history not been prepared to countenance complete limits on the alienation of property, because that would stranglehold the use of property. And that's where we then move into the rule against perpetuities, and that is a rather technical area. I don't want to go into that too much at the moment, but it's a bit sort of challenging, and you just need to work your way through it. It's governed by specific provisions of the Property Law Act and case law, and it deals with situations around attempts really to prevent property being alienated and to lock it up, and how the law has responded to that, initially through the common law, but then through a legislative scheme, as we'll see under a particular part of the Property Law Act. From there, we move on and we look at a big area, and that is a practically important area, and that is the law of leases or leasehold interests. Again, when we touched on the doctrine of estates back in property law, we saw that there are different types of estates that you can have in land, and one of those is a leasehold estate or a leasehold interest. So we want to investigate the nature of a lease. Our focus is to a large degree on the common law of leases, and we also look at other particular areas of leases that are governed by specific legislation, again in Queensland, and the two that are the standouts are residential tenancies, for which there is specific legislation in Queensland, and also retail shop leases, for which there is specific legislation if the situation is governed by that particular legislation, and that's an important qualification. And that's a big topic, and you can see we've got basically 11 topics there, and we may end up spending 2 weeks on the law of leases. We'll see how we go. Okay. I've then introduced a new area, which is not a traditional area in land law studies, but I think it's an important area and one of growing importance, and that is the area of social housing. I could also add to that community or affordable housing. This is an area largely governed by legislation. There's very little case law on this because of the way it is operated and because of the way the disputes have been resolved, and the fact that property law features in terms of relationships between the key stakeholders hasn't been the way that disputes have been resolved because of the particular nature of the funding arrangements, how the legislation works, and the relationship between funding agencies and funded organisations that manage housing on behalf of the government, but today also have the possibility to actually own housing and leverage more finance into the sector in that way. So we'll look at that as an important area because there are significant challenges to housing affordability in modern Australia. Not everyone can be involved in land transactions in terms of sale and purchase of private freehold, and so this space is an important area to be aware of and the law that affects that. We then move on to an area which is referred to as easements, and these are what are referred to as using very technical terminology, which will go back again to foundations, and we looked at terminology there. They're called incorporeal hereditaments, and they're sort of they're rights over land, but it doesn't give an ownership claim, but they restrict use in a way that is important, and we'll see how that works. And importantly, they can be recorded on the land title and registered under the Torrens system. We then finish the unit by looking at the law of mortgages and the property law features that govern the relationship between a mortgagee and a mortgagor. Now, we touch on mortgages earlier in the course in the context of the Torrens system, and that is in relation to the nature of a mortgage and how that links into indefeasibility and so on. But in topic 10, or in week 10, we will look at how the law of mortgages deals with the rights and responsibilities and obligations between mortgagor and mortgagee, the nature of a Torrens title mortgage in particular, and what happens when problems arise. And of course, a mortgage is the security interest which underpins the financing of the acquisition of property and a loan contract. And what happens, for example, if a mortgagee, which is the financier or the creditor in a loan contract, wants to take action when there's been a default on repayment of the loan, for example, and then what can they do, what can't they do, and how does the law govern and deal with that? And we need to also be mindful in that context of, in the context of Torrens title land, what is the nature of the interests that are held by a mortgagor on the one hand and a mortgagee on the other. Right, so that's where we're going in the unit. just going to come back to the slides. So returning to this idea or this theme of the concept of land, you can see there, and this is taken from an earlier edition of Land Law, the text by Peter Butt, the 6th edition, that's the predecessor of the current edition. But I've kept this in there because Brendan has explained this a slightly different way, but I think this is a very nice description that Peter has provided in as he had developed the text over many years. And you can see there's a focus on spatial understanding. So this 3-dimensional quantum of space, as we know from our studies in property law, this can include airspace, it can include going under the surface of the soil. And all of this environment of space forms part of what is land for the purposes of property law. And it is about how we can transact in that space. And as Peter indicates there, it's more than those fixed contents, because if the contents of the space are physically severed, destroyed or consumed, the space itself and so the land remains. So in this sense, land is indestructible. So that is an interesting idea. And that's why land is referred to as an immovable. Going back to that terminology we discussed back in foundations, we talk about, one type of classification or terminological explanation is movables and immovables. So that land is an immovable. You can't shift it around. You can't move it around. It doesn't work, right? Whereas personal property are movables. But as we saw in foundations course, of course, personal property can become part of the land through the doctrine of fixtures. So we need to get this spatial understanding of what can incorporate land. And that, of course, then allows us to understand that the definition of land for legal purposes and for land law purposes doesn't only include the physical surface of the soil, as I indicated, the space above and below, but also improvements to the land, which is about dwellings and other features. Now, a different explanation has been provided by Edgeworth in his edition of Butt's Land Law, what is now Butt's Land Law. His focus is that land law plays a central and indispensable role in the sustenance of life itself. So it's a more, not so much a sort of pragmatic understanding of configuration of space, but Edgeworth is now forcing us to think about, well, but what role does land play in the nature of the society, in the nature of the world we inhabit, the human world, if not more than that. Rights over land are therefore among the most fundamental of all legal rights, underpinning individual flourishing, the stability of relationships and broader social cohesion. This takes us back to the social purpose of law. Think about this idea in terms of what comes from having a stable environment of livability or habitation. Think about what comes from having an environment from where a business can be undertaken and performed. But today, of course, we need to understand the impact of electronic technology and that many things can now be done electronically. But even so, they are done often, if not always, through a device, which is an item of property, okay? And from a location. As human beings, we actually need to be sited somewhere to do something. We can't just be forever transient. But Edgeworth takes us further. At the psychological level, land law's influence is no less significant, insofar as it may afford both a refuge from the world and a location within the world. Land is essential for both personal privacy and security. That's a really interesting idea. This idea that it affords a refuge, but also a location, a site within the world. It gives you a sense of identification, but it also gives you a sense of protection. Think of your own situation. What if you didn't have land? What if you didn't have a space of continuing habitation? What if you didn't have an environment within which business could be conducted? In terms of habitation, you then find yourself potentially being a homeless person. How do they interact with the world where they don't have the same relationship to land that many of us do? Edgeworth pushes a bit further and says a home is essentially, but not simply, a place to live, protected by a bundle of land rights. Its further importance lies in its role in constituting identity. Powerful ideas, people. Powerful ideas as a lever to take us into some of the more pragmatic ideas that we'll explore in the coming weeks, coming topics. Just this idea of a home. It is interesting that, you know, in the broad popular understanding, one reads about home ownership, purchasing homes, but in social, public and affordable spaces, you talk about social, public and affordable housing. You don't talk about social, public and affordable homes. When you rent something, you rent often a dwelling, you rent an apartment, you rent a house, you don't rent a home. Why is there these differences of description? This idea of place, protection, the rights that you have, and then who you are through this relationship to land in connection is very interesting. It's almost starting to sound a little bit like native title, isn't it? My goodness. Could that be possible? Not entirely, but we have a different relationship to land than Indigenous Australians, but it is interesting to see it in these terms. So I've given you an additional resource here, which is Australian Real Property Law, and that from another case book, and you've got that reading which is in Moodle for this topic. And basically that is giving you opportunities to think about the nature of Australian Real Property Law, to look at the development of the real property law that we have in Australia, and then also to give some consideration to social purpose, as I've been suggesting. When we think about the nature of Australian real property law, then we need to think about opportunities and we need to think about challenges. Opportunities are in terms of paperless records and transactions, enhanced efficiencies in land transactions and dealings, and universal and common access by all stakeholders. This idea of the role of technology moving from paper-based to a paperless system, this is about the impact of electronic technology. It is about electronic conveyancing. It is about the fact that in Queensland, title documents are electronic. It is under the Land Title Act, Torrens title documents. It is about the fact that instruments today in land transactions in regard to private freehold are electronic instruments, transfers, mortgages, instruments that affect unregistered interests and other types of interests. The idea of universal and common access is interesting. So this embraces the idea of, well, how do you get access and who should have access? The Torrens Register is a public register. Anyone can go in there and search. There will be a fee. And so, you know, even before, it's not in Queensland, it hasn't been commercialised, but there is an administration fee to do a property law search or a title search. But so long as you have the title particulars, you can go in and you can have a look. Something else that we're going to look at in the next few weeks is something called Queensland Globe 2017, which is a spatial and a cadastral mapping software, which is electronic, and which you can even today under the Mark II 2017, you can download it onto your mobile device via an app, and you can via that look spatially at all land in Queensland and even beyond Queensland in some situations, and all the various features that affect land, and you can even do a three-dimensional have a three-dimensional view. There is different layers that you can go through to find different information, including property law information and including things that interests and so forth that affect the land. We'll talk more about that. So there's this idea that technology is having a very significant impact. In terms of the challenges, increased risks of fraud and manipulation, yes. Scams, something referred to, and I'll give you some resources on this, something called deep faking with regard to audio and visual. Identity verification of identity protocols under electronic conveyancing arrangements, and also recognised now in regulatory instruments such as, for example, the Land Title Practice Manual, which is a comprehensive administrative explanation of all the various aspects of the Land Title Act. We'll introduce that to you in the next lecture. And those VOI protocols are very important in the electronic conveyancing space today. And we see that idea of identity and the verification is important in the paperless environment or the electronic environment, and then issues around access barriers through technology and so on. Very important also to just identify at the outset that electronic conveyancing is not currently mandated in Queensland. It is mandated in 3 other jurisdictions, that is New South Wales, Victoria and Western Australia, for variously in either in standard sale and purchase transactions or potentially for all transactions, but not in Queensland. So these are the opportunities and challenges within the environment going forward. I don't want to go too much into this. You can have a look at that in the material with regard to how Australian real property law has developed and evolved over time. I just want to touch on the idea of the development of a legal framework. So just to spot the fact that we need to, as I've already mentioned, appreciate the central role of the Property Law Act and the Land Titles Act, how easements are dealt with under Queensland law. There's a reference there to covenants. We're not covering covenants in the unit. We can't cover everything. We have to make choices, but that is an area that you could look at independently as you feel the need to. The also important point about the lack of uniformity of Torrens legislation across Australia. There's been a lot of talk about the need for moving towards a uniform Torrens framework. That hasn't happened yet. I'm going to just show you a paper at the moment that is about an ongoing, review or reform of what's transpiring in the electronic conveyancing space, which is sort of nudging moves in terms of the Torrens framework. But we still have state-based legislation at the moment, and in Queensland that's the LTA. And also just to be conscious of the fact that we have land planning legislation regulation, which is impacting around the use of land and so on. We don't go into that in this unit, we're dealing with fundamentals, if you like, and that can be done in another context, and there's a large body of material on that, just to have an awareness of those other features that impact upon how land is regulated and governed. Now, I've touched upon this a bit in terms of social purpose, this tension between efficiency on the one hand and equitable distribution of rights on the other. So efficient use of land for a purpose, but that rubs up against the fact that, well, don't all members of the community have a right to property and to a distribution of those rights. The waxing and waning of property ownership and how property law has responded to that from the perspective of wealth and power within the Australian society, and how that's evolved over time, and particularly since the post-war period, post-Second World War. And then this whole notion of home ownership, housing, what's done in regard to social and affordable housing, and the intervention by the federal Parliament through overarching legislation, which up until the Rudd federal government, that was referred to as the Commonwealth State Housing Agreements, which basically ran from 1945, the first of those, through until Kevin Rudd introduced a new regime, which we'll refer to when we get to the social housing topic. So that's all part of the mix in terms of social purpose. Right, so just before we wrap up, there's a couple more things I want to point out to you. And right, so I'm just going to screen share a couple of things here with you again. So this is, and this is uploaded onto the welcome page of the unit Moodle. This is a review which was undertaken over a couple of years by the Commercial and Property Law Research Centre at Queensland University of Technology. And this culminated in late 2018 in this final report on the review of the Property Law Act 1974. Now, the report's an enormous document. It's nearly 1,000 pages. And I have given you access, an uploaded the entire report there, but it's not at all intended for you to be working your way through that. But what I would just point out is, in the table of contents, be mindful of the areas that are touched upon that come out of the Property Law Act that we are going to be looking at in the unit. So, for example, there's a lot of comparative discussion there, which is quite useful from a reform and policy perspective. But, for example, freehold estates, yes, to some degree, but not, we are looking at more specific things. Concurrent interests, co-ownership, part 5, we deal with the topic on co-ownership. Right, trusts and so on, we don't tend to go into. We've done that, as you know, back in property law. You will find that there's also specific areas dealing with other areas that we touch on in the course. I won't go through all this, but it is dealing with the range of topics, including things like mortgages, because you'll find that the Property Law Act is relevant in this context. So the Property Law Act becomes relevant in the area of co-ownership, leases, the general law of leases, mortgages, to some extent easements, these specific property land law interests that have been identified. And also there's some sort of overlap or impact, if you like, of the Property Law Act with regard to Torrens environment, put it like that, even though that's governed by the Land Title Act. I also just want to, so from there, I want to just also bring to your attention that the PEXA website is very important. And whilst we're not specifically doing study on electronic conveyancing in the unit, there will be reference to electronic conveyancing. There will be opportunities to experience this, including through the assessments, which I'll come to in a minute, as you progress. So just go onto the PEXA website, familiarise yourself with that, look at the various features. You can see there's a whole range of features. There's tutorials, materials that indicate how to, various aspects of the site and so on, in terms of an electronic conveyance. And then the other document that's just been uploaded onto the welcome page of the Moodle website, this is a review of the Intergovernmental Agreement on Electronic Conveyance and the Electronic Conveyancing National Law. It's just interesting to have a look at this, and again, it's just to look at and to think about it in terms of where these developments are progressing, because we are certainly by no means are we at an endpoint. The developments are becoming exponential, if you like, and we're really just in the first wave of these significant changes. It's going to arguably have the potential to revolutionise how property law transactions take place and the future and the role of property lawyers in that space. So have a look at that document when you get a chance. Right, so there's a fair bit there as a way of introduction for you to get a sense of. The other thing I'm just going to mention too, and I'll put a few additional resources up around this, and again, mostly in terms of from an information perspective and an awareness perspective, but I'm going to mention something now, again, in the electronic environment, hasn't really landed as a direct impact just at the minute, but it is certainly on the horizon and it will have transformative implications in the future. And that is something referred to as blockchain technology. And within blockchain technology, we can think of different platforms. Ethereum is one, and Facebook is getting involved a bit in this because this also involves cryptocurrency. So as I say, I'm going to put a few links up about that for you, just for you to think about and consider, but that's something into the future. It's not here and now. So it's just, again, to be mindful of how this is going. This is a very moving feast in terms of what we're doing and thinking about this environment. So just by way of close, I'm just going to go back to the slides momentarily. So basically, what we've been looking at in this presentation is concept of land, how do we think about land, to reflect upon the development of Australian real property law, to appreciate the purpose or the social purpose of real property law, but also to be mindful that we are in an environment of change and that environment of change is significantly affected by technology, electronic technology, of course, in particular. And there are developments that are currently impacting the nature of land transactions and dealings and instruments. There are even more significant changes going forward that haven't yet, as I mentioned, landed, to use that phrase, in terms of immediate change in the Australian landscape, but things are occurring in other parts of the world. And I'm just going to stop screen sharing that. And just to also be mindful that one of the big takeaways from this unit is to get a sense of both the current environment of law and regulation with regard to land dealings and land transactions and interests in land, but also to be mindful of the future and how we are transitioning from a paper-based environment to a paperless electronic environment in almost all, not entirely in all respects, but in very significant areas. Again, as I mentioned earlier, not mandated yet in Queensland, but that may well be the future. So, folks, hold on, because it's going to be an exciting ride and an exciting journey over the next 3 months, 12 weeks. We're going to do a lot of different things. Just before I go, I said I would do this, and I'm just going to go back and just want to go back to I'll go back now to the Moodle website and just find my Moodle website. No, it's not my Moodle website. Get to my Moodle website, and there we are. There it is. There we are. Good. I just want to just finish by focusing on assessment. Okay, so that's really important. And you'll see there are 3 pieces of assessment in this course. There is a 20% online assessment, there is a 30% online assessment, and there is the 50% final invigilated exam, 2-hour exam during the exam period. And the 20% assessment will be released either at the end of week 1 or at the beginning of week 2. I'm hoping to get it out probably by the end of week 1. And you'll have about 4 weeks in which to do that, because you can see there that it will be due on the Friday the 16th of August, which is week 5. And the 30% assessment will be released at that time when you hand in your 20% assessment, and it will be due on Friday, week 8. So you'll have approximately 4 weeks in which to do that, because there's a 1-week midterm recess with regard to that. And that can be done in groups of up to 4 students, just like the second assessment or the second online assessment was able to be done in property law. And then there's the final invigilated exam. We'll talk more about the exam as we go forward, particularly with your experience of having done the property law exam. And in particular, we'll talk about what are effective ways to approach doing an exam in this area of the law in that 2-hour window. And I think some practice can be done in that space, and some thought can be given to the nature of the exercise and techniques and strategies for improving outcomes and success. So we will find ways to do that as we progress. So there we have it, people. Week 1, first lecture on land law. Welcome aboard, and stay engaged and stay excited. See you next time.